SwayamPrabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 21st lecture, and the topic of today's presentation is rights of accused under criminal justice system. So, in this lecture, I would like to discuss rights of the accused available provided in the Constitution of India and rights of the accused provided in Universal Declaration of Human Rights 1948, and then after I will try to discuss statutory provisions regarding rights of accused under Indian criminal justice system, and then after I would like to discuss role of Supreme Court in protection of human right, how Supreme Court has been effective in protection of rights of accused. So, with the help of these four important segments, we will try to understand the rights of accused under Indian criminal justice system as well as under international instrument. So, you look at this screen. I have made this slide so that you can get entire information regarding rights of accused under criminal justice system, rights of accused under Indian Constitution, statutory provision for the accused, and third is role of Supreme Court in recognizing rights of accused. So, we will try to understand rights of accused under Indian Constitution, under Indian legal framework, statutory provisions regarding rights of accused, and then after role of Supreme Court one by one. So, let us start with the Constitution. As you all might be knowing that Indian Constitution, Article 21 of the Indian Constitution talks about right to life. I have mentioned this, you just look at your screen. Right to life as a human right, it is also fundamental right under Article 21. Protection against ex post facto laws, Article 20 clause 1, Article 20 clause 2 and Article 20 clause 3, protection against self incrimination, Article 22 and 21 and Article 22, right to be produced within 24 hours and right to have counsel. So, let us start with Article 20 clause 1. As you might be aware about Article 20 clause 1, it provides an opportunity to an accused to take defense, to take protection whenever a person against whom criminal proceeding is going on and a person against whom criminal proceeding is going on and that person who has committed such an act which the act was not offence on the date of commission of the act, but later on the act was criminalized by the statute. So, Article 20 clause 1 gives protection to that act which was not offence on the date of commission of the act. That act cannot be considered as, so no person can be prosecuted and convicted for that act which was not offence on the date of commission of the act. So, this kind of protection which is given under Article 20 clause 1, that is known as protection against ex post facto law. So, the moment a person is to be prosecuted for that act which was not offence on the date of commission of the act, at that very moment he or she can take protection of Article 20 clause 1 of the Indian Constitution before High Court or Supreme Court. And this would be violation of fundamental right guaranteed under Article 21 of the Indian 20 clause 1 of the Indian Constitution. So, this is kind of protection, this right is available to every suspect, every accused. Now, come to Article 20 clause 2, double jeopardy. So, Article 20 clause 2, that is also a fundamental right given to an accused, where a person who has already been convicted and prosecuted and convicted, that person cannot be prosecuted and convicted for the same offence. So, it would be violation of his fundamental right guaranteed under Article 20 clause 2 of the Indian Constitution. So, this is known as protection against double jeopardy, which literally means no person can be punished twice for the same offence. So, Article 20 clause 2 also gives liberty to an accused to take protection, to take defence whenever he or she is going to be prosecuted and convicted for the same offence where he has already been convicted and prosecuted. So, this right is available to each and every accused who has already been convicted, prosecuted and convicted. Third important right available to an accused, that is Article 20 clause 3, protection against self incrimination. No person can be compelled to be a witness against himself. Article 20 clause 3 specifically talks about that whatever statement is given by a person under compulsion, that statement cannot be considered as a piece of evidence according to Article 20 clause 3, it would be violation of fundamental right. So, this kind of protection is also available under Article 20 clause 3 to each and every accused, and where a person who is an accused of an offence is compelled by a police to confess his guilt or to make such a statement which might implicate him in any offence, he can take defence of Article 20 clause 3 and he can say that he is not bound to confess his guilt, he is not bound to give that statement which might implicate him in any offence. So, this kind of protection is available under Article 20 clause 3. Another important right, Article 20 talks about 3 important rights: protection against, right against ex post facto laws, right against double jeopardy and right against self incrimination. So, this is all about Article 20. Now, come to Article 21. As you all might be knowing that Article 21 talks about right to life and personal liberty. Every person has right to live with human dignity. No person shall be deprived of his life or liberty except procedure established by law. So, meaning thereby any person can be deprived from his life or personal liberty with procedure established by law. So, even this right to life is not absolute right, but Article 21 of this Constitution gives liberty to a person to live with all human dignity. He can enjoy his life in his own way. So, right to life is a fundamental right, but this right to life is not absolute right. And I will discuss each and every aspect of right to life, where Supreme Court has widened the scope of right to life, where a person who is poor, who is unable to engage his advocate in the court of law, then this right to life would be meaningless for that poor person who is unable to engage his counsel in the court of law. Due to poverty, right to life for that poor person who is unable to manage his food, livelihood, that right to life would be meaningless for that poor person. That right to life would be meaningless for that poor person who cannot access to the justice, he cannot approach the court, he cannot get justice due to poverty, then right to life for that poor person would be meaningless. So, for these reasons Supreme Court intervened in this area, and Supreme Court through different judicial pronouncement has recognized that right to food is a fundamental right, right to shelter is a fundamental right, right to legal aid is a fundamental right, right to free legal aid fundamental right. So, you might be knowing that Article 21 has got new impetus, and that is only because of Supreme Court. Supreme Court has widened the scope of Article 21, and just because this right to life would be meaningless if people, poor people, if they die due to starvation, due to hunger. So, that right to life would be meaningless. I will try to explain all these things in coming session. Now, another important component of rights of accused, that is given, provided under Article 22. Article 22 talks about legal representation. Every person has fundamental right to take legal assistance from a counsel, from advocate. So, every person has right to consult from his advocate of his own choice. This is specifically provided under Article 22, and Article 22 is more powerful in that sense when it gives liberty to a person, arrested person, to be produced within 24 hours from the time of arrest. So, where a person who is arrested and that arrested person is not produced within 24 hours from the time of arrest, it would be violation of his fundamental right provided under Article 22 of the Indian Constitution. This right to be produced within 24 hours from the time of arrest, this fundamental right has been guaranteed as a fundamental right only due to protection of fundamental rights of the citizen of this country, so that police officer, arresting officer cannot commit custodial violence, cannot commit police atrocity. So, in order to avoid police atrocity, in order to avoid police custodial violence, our constitution makers were very much aware about the functioning of the police. So, in order to protect life and limb of citizen, in order to protect fundamental freedoms, fundamental rights, right to life of each and every person, our constitution makers deliberately they inserted this provision in part 3rd of the Indian Constitution. Students, you all might be knowing, you must understand the significance of Article 22 of the Indian Constitution, which talks about right to be produced within 24 hours from the time of arrest, and right to legal representation, that every person has right to consult of his own choice. So, even Constitution being supreme law of the land provides these important rights, fundamental rights to arrested person, to accused. So, you see even criminal justice system derives its authority from the Constitution itself, that Indian criminal justice system, which we mean 4 vital component: police, prosecution, judiciary and jail, prison. So, these systems are constitutionally bound to pay respect to all these fundamental freedoms provided in the part 3rd of the Indian Constitution. Police, prosecution, judiciary, they are bound to ensure that a person who has been arrested by the police, that police is under constitutional obligation to produce that arrested person within 24 hours from the time of arrest. It is constitutional mandate for the judiciary to ensure that whether a detainee, whether an arrested person who has been brought before the court has been produced within 24 hours from the time of arrest or has been produced beyond that period. If that person has been produced beyond that period, then judiciary court can declare that detention unconstitutional, because it is against the spirit of the Constitution. So, you all need to remember all these provisions, Article 20, 21, 22. Now, coming to right of accused under Indian legal framework. Now, we will try to understand that what are the statutory provisions which are specifically designed for accused, which are specifically deals with rights of the accused. So, we will try to understand that what are those statutes under which accused they have right to get their claim, what are those statutes under which accused are entitled to get, not to be tortured, not to be assaulted by investigation agencies or other agencies. So, let us understand. With the help of this slide, I would like to throw some light on rights of accused under Indian legal framework. So, you can see right to, the first important thing is that right to know the ground of arrest. So, this is most significant provision of the Criminal Procedure Code 1973, that is, every arrested person has right to know the ground of arrest, and this right is recognized under section 50 of the CRPC. So, section 50 CRPC talks about right to know the ground of arrest. Right to legal aid, section 303 CRPC. Right to free legal aid, section 304 CRPC, and right to appeal. This right to appeal is given from section, as you all might be knowing, the section 372, 394 CRPC. So, right to legal aid, 303 CRPC, I have already discussed article 22. So, 303 CRPC also talks about legal representation, that in criminal case every person is entitled to have a counsel. It meaning thereby every person needs legal representation. Every person against whom legal proceeding is going on, a person who is a suspect or accused is entitled to get legal aid of his own choice. He can have advocate, he can have his own advocate or counsel. So, section 304 CRPC is more wider than 303. You see, section 304 CRPC talks about free legal aid. Right to free legal aid, that is fundamental right, as Supreme Court has already recognized this right to free legal aid as a fundamental right in M.H. Hoscott versus State of Maharashtra, AIR 1978 Supreme Court. In that case, Supreme Court held that poor people who cannot engage their counsel, it is constitutional obligation of state to provide counsel free of cost. So, right to free legal aid is fundamental right, and because of Supreme Court, but the Code of Criminal Procedure 1973 specifically talks about free legal aid in criminal case, and that is specifically provided in section 304 CRPC. So, you need to remember these two important provisions, section 303 CRPC and 304 CRPC. Another important right which an accused can claim, that is right to appeal. Dear students, as you might be aware about right to appeal. Right to appeal is a statutory right, and it is specifically provided in section 372 of the CRPC, that unless otherwise provided in this code, no person shall have right, means unless otherwise provided in this code, no appeal shall lie against order of the court. Meaning thereby that right to appeal is a statutory right, but this right to appeal is subject to fulfillment of certain condition. This appeal shall lie against the order of the subordinate court only when there is clear cut provision in the statute. If this statute CRPC has prohibited the court not to accept any appeal from the lower court, then no appeal can be accepted by High Court or Supreme Court against the order of the subordinate court. As you all might be knowing that article section 375 and section 376 of the CRPC talks about no appeal in certain cases, and no appeal shall lie against the order passed by the subordinate court. So, section 375 and 376, these two provisions talks about under what circumstances appeal cannot be accepted by the appellate court. So, this right to appeal is a precious right in under criminal justice system. Every accused can make an appeal against the order of the subordinate court, but all the judgment orders passed in criminal case are not appealable, cannot be made appeal against any order passed by the trial court, passed by the criminal court. So, section 375, 376 you will have to remember these two important provisions. Every accused who has been convicted by a trial court in a murder, that murderer who has been convicted by a trial court, by a session court, has right to make an appeal against conviction in the high court. If high court has also upheld the conviction order passed by session court, then that convicted person, offender, has right to make appeal in the Supreme Court under section 374 CRPC. So, appeal against conviction provided under section 374 CRPC. Article 134 of the Indian Constitution also talks about appeal in criminal cases. Article 134, you might be knowing that constitutional law, Article 134, where High Court has reversed the acquittal order of the session court and convicted, and death sentence has been awarded in that case. So, that accused whose order has been reversed and has been convicted by the High Court for death sentence has right to make an appeal in the Supreme Court. So, this is all about right to appeal. Now, come to rights of the accused. Right to bail. So, this slide you look on your screen, right to bail, section 436. When a person can demand for bail, default bail, I have chosen three important component: default bail, right to be examined by medical practitioner. So, let us understand about all these three things. Right to bail, section 436. Dear students, section 436 of the CRPC imposes an obligation upon the criminal court to release an accused against whom the allegation is about bailable offence. Bailable offence is that offence which is shown as a bailable in the first schedule of the CRPC. Generally, bailable offences are those offences which are punishable with less than 3 years imprisonment, and where allegation against a person is made, that person has committed offence which is punishable with less than 3 years imprisonment, that person is entitled to get bail as a matter of right from the court, and criminal court is also bound, obliged to grant bail to that accused who has committed bailable offence. So, in bailable offence, bail can be claimed as a matter of right by the accused. On the other hand, in non-bailable offence, grant of bail or rejection of bail depends upon the discretion of the court. Court may grant or may not grant bail in non-bailable offence. Non-bailable offences are more serious, heinous crimes. So, that is why in non-bailable offences, criminal courts are not supposed to grant bail unless conditions are satisfied. So, you need to remember that those conditions which must be satisfied before the grant of bail. I do not want to go into the technicality of that area. So, here I just want to confine myself only towards three things: right to bail. So, you need to understand that right to bail is a statutory right. This is not a fundamental right. Right to bail is a statutory right, and statute is CRPC, the Code of Criminal Procedure 1973, section 436 has imposed legal obligation upon the trial court to grant bail to all those accused who have committed bailable offence. So, in bailable offence, a person, an accused can get bail from the court as a matter of right. Second important thing is default bail. As you might be knowing that default bail is given under section 167 CRPC. Section 167 CRPC talks about remand. You just look at your screen, default bail. I want to mention the date: 15 days, 19 days and 60 days and 7 days executive magistrate. All these informations which I have mentioned on this slide, you just can memorize all these 4 important elements. Section 167 talks about remand, and this remand can be granted by criminal court, by judicial magistrate. 15 days police remand, judicial remand, 90 days where a person who has been prosecuted for committing such a crime which is punishable with death sentence or life imprisonment or offence more than 10 years punishment. In that case, investigating officer has to submit charge sheet within 90 days, investigation must be completed within 90 days, or you can say that police can take remand up to this 90 days, where offence is punishable with less than 10 years imprisonment. In that case, this period of remand can be extended from 15 to 60 days. So, 60 days remand, 15 days remand, this is purely police remand and judicial remand. I have already highlighted in my previous lecture that what is basic difference between police remand and judicial remand. Here what I am trying to justify, that section 167 which talks about remand, that also gives liberty to an accused to file a bail application after the expiry of 90 days or 60 days as per the case, and after the expiry of 90 days or 60 days where police officer, investigating officer has failed to prove charge sheet in the court, then after the expiry of 90 days court may grant bail to the accused. So, after the expiry of 90 days or 60 days depending on the nature of case, it is the right of accused to get bail from the court. So, I have already highlighted that these are the offences of serious nature, non-bailable offence. So, grant of bail or rejection of bail, this is the sole discretion of the criminal court. Criminal court may grant bail or may not grant bail. I have used default bail for 167 CRPC, default bail because due to the default of investigating officer, accused is released on bail. Accused is granted bail only due to default of the investigating officer, where what kind of default? Because investigating officer has failed to complete investigation within 90 days or 60 days, or has failed to provide charge sheet within 90 days. So, you need to remember that is why section 167 which is directly connected with remand is also known as default bail. It also deals with section 167 also talks about default bail. Right to be examined by medical practitioner, that is another important right of the accused. Right to be examined by medical practitioner. You can look at your screen. I just want to mention relevant provision of the CRPC, section 54 CRPC. Section 54 CRPC provides that every arrested person has right to be examined by medical practitioner. Soon after the arrest, arrested person shall be examined by medical practitioner. So you see, this medical examination, it serves two purposes. One, examination of medical examination of accused will serve two purposes. One is that police investigating officer can use that medical report in his own defense, where allegation is made by the accused against the arresting officer that during interrogation at the time of arrest, arrested person was assaulted or custodial violence was committed by the arresting officer. So, in order to take defense, investigating officer soon after the arrest, arresting officer soon after the arrest may conduct medical examination of the arrested person. It would be beneficial for both. It would be beneficial for the investigating officer as well as accused, both. Why it is beneficial for the arresting officer? Because whenever the allegation on behalf of accused is made against the arresting officer that at the time of arrest force was used by arresting officer and injury was caused by arresting officer, then on the basis of medical report, arresting officer can take defense before the court that at the time of arrest, the medical report prepared by medical doctor was good. This honorable court can see the report prepared by doctor at the time of arrest. In that medical report, doctor has specifically mentioned in that medical report that neither injury nor any scratches were found on the body of the accused. If this kind of statement is written in that medical report, mere allegation made by an accused against the arresting officer would not be sufficient unless. So, this medical report, you see, medical examination report would be helpful for the arresting officer. It would also be helpful for the arrested person. If he is having medical report, if his medical examination is conducted by a doctor, medical practitioner, then he can prove before the court that he was assaulted, that accused was assaulted, or he was confined in this manner, or so it would be beneficial for both accused and police officer, arresting officer. Right to be examined by medical practitioner. Now come to protection against self-incrimination. This is right available to an accused, protection against self-incrimination. I have already highlighted in previous lecture, you can just see on your screen that protection against self-incrimination is given under Article 20 Clause 3, no need to discuss again. Effect, where compulsive statement is obtained by investigating officer, what would be the effect of that statement which is obtained by investigating officer is provided in section 24, 25, 26 of the Indian Evidence Act and section 162, 163 CRPC. No inducement or threat shall be given by investigating officer to the accused. No inducement or threat shall be given by investigating officer to the accused. Now, let us understand the effect of non-compliance of Article 20 Clause 3. You see, you need to remember that under Article 20 Clause 3, authority has been prohibited not to record not to obtain such a statement which might implicate him in any offence. So, that is prohibited. But if a statement is obtained by investigating officer, then what is the remedy available to that accused? Accused can check the constitutionality of that statement which is obtained by investigating officer in violation of Article 20 clause 3. So, he can challenge the constitutionality of that statement before High Court or Supreme Court. You are free to approach High Court or Supreme Court. If a statement has been obtained, then what would be the consequences of that statement? It is provided under section 24, 25 of the Indian Evidence Act. Section 24 says that no threat or inducement shall be given to the accused for what? To obtain confessional statement. No inducement, no threat shall be given by investigating officer, interrogating officer to the accused to obtain any statement. Then now come to section 25 and 26. Statement obtained by investigating officer shall not be accepted as a piece of evidence if that confession was made by an accused to the police officer. So, section 25 says that where confession is made by an accused to the police officer, that confessional statement cannot be accepted as a piece of evidence against the statement maker. And section 26 makes it more clear and says that section 26, I am referring, confession made by an accused in police custody would not be considered as important piece of evidence. So, you all need to understand Article 20 clause 3, 20 clause 1, 20 clause 2. Now, let us understand the role of Supreme Court in protection of rights of accused. In this lecture, we will try to understand that what is the role of Supreme Court in protection of rights of accused. So, with the help of case laws, we will try to understand how Supreme Court has contributed, how Supreme Court has played a vital significant role in protection of rights of accused. So, I will discuss one by one. The first case is Khatri vs. State of Bihar, AIR 1980 Supreme Court. This case is popularly known as Bhagalpur blinded prisoner case, Khatri case. In this case, Supreme Court for the first time held that right to have a counsel at the time of investigation till the completion of trial, you just correct it, till the completion of trial. So, the most significant judgment on the rights of accused is Khatri vs. State of Bihar, AIR 1980 Supreme Court. In this case, Supreme Court for the first time held that where accused are poor, they are entitled to get legal aid free of cost right from the investigation till the completion of trial. So, this right to legal aid will start soon after the arrest and it will continue till the completion of trial unless the trial is over. So, it is the duty of police to provide advocate counsel free of cost. It is the duty of court to provide counsel free of cost, because police and judiciary both are essential component of criminal justice system, Indian criminal justice system. Khatri vs. State of Bihar, AIR 1980 Supreme Court. Then right to free legal aid was recognized as a fundamental right in M.H. Housecott vs. State of Maharashtra, AIR 19. Citation is very important. So far as citation of M.H. Housecott vs. State of Maharashtra is concerned, you must correlate this citation with citation of Menka Gandhi. So, just for your convenience, I have linked these two decisions. These two decisions are contemporary. So, you all need to remember. In this case, right to free legal aid was declared as essential component of right to life or personal liberty. That right to life would be meaningless for that poor person who cannot afford court fee or advocate fee. Due to poverty, he cannot get justice. For that poor person, right to life would be meaningless. So, this observation was made by Supreme Court in M.H. Hoscott versus State of Maharashtra. Another aspect of role of Supreme Court in protection of rights of accused too, I have chosen this slide. So, you see in this slide, this is right of accused part 2, you can say. So, rule of Supreme Court in protection of rights of accused. So, I have referred to important case laws. Hussain Ara Khatun versus State of Bihar, Shelvi and others versus State of Karnataka, AIR 2010 Supreme Court. You might be aware about one maxim that justice delayed is justice denied. So, Supreme Court in Hussain Ara Khatun versus State of Bihar for the first time held that right to speedy trial is an essential component of right to life or personal liberty. Where person who is deprived from getting justice within prescribed time, it would be violation of his or her fundamental right, and in case of violation of fundamental right or human right, aggrieved has right to come before High Court or Supreme Court directly without knocking the door of district court, subordinate court. You need to remember this thing. So, in Hussain Ara Khatun case, what happened in this case, I just want to express. In Hussain Ara Khatun case, there were 6 female offenders, prisoners who were languishing in jail. Since they belonged to poor family, they were not in position to fight their case in the court of law. So, it was decided by a lawyer, Kapila Hingorani, to fight their cases, and she mustered her courage to fight against the government. In this way, when matter was brought into the notice of Supreme Court for the first time got opportunity to decide this case, and in this case Supreme Court said that right to speedy trial is a fundamental right, where judgment is not tried expeditiously by the trial court, High Court and Supreme Court consider that case as a violation of constitutional mandate, as a violation of contempt of court, right to speedy trial. Now, come to another aspect of speedy trial, rights, protection of rights of accused. How Supreme Court has been effective in protection of rights of accused, I would like to highlight one important, a leading case you can see on your screen, Shelvi and others versus State of Karnataka, AIR 2010 Supreme Court. So, what actually happened in this case, Shelvi case, Shelvi and her 3 guilty partners, they were involved in killing a man. The facts are, the daughter of Shelvi wanted to marry with a man of different caste. So, Shelvi tried to convince her daughter, but daughter was not ready to accept the proposal of her mother. So, she decided to marry with that man, but before that marriage, Shelvi along with two guilty associates, they decided to finish the deceased from life of Shelvi's daughter, and they killed. When matter was brought under notice, police filed a charge sheet. So, you see, then Shelvi went in appeal challenging the order of the trial court, where trial court had ordered to the investigating agency that you investigating agency, you all are free to use narcoanalysis or brain mapping to the accused. So, this kind of plea was made to the High Court, then Supreme Court intervened in the matter. Supreme Court said no, right to life, that is fundamental right, and right to privacy that is essential component of right to life. No person shall be compelled to disclose his privacy. So, right to privacy is a fundamental right, and an accused who is not willing to go under narcolepsy test, brain mapping test, any kind of compulsion over the patient, over the accused will make the decision void. So, Supreme Court for the first time recognized that in Selvi case for the first time recognized that narcolepsy test, brain mapping test can only be used to gather the information, but whatever statement is obtained by using chemical in narcolepsy test or brain mapping test, that statement shall not be considered as a piece of evidence, and on the basis of statement given by a person who is under custody, that statement cannot be considered as piece of evidence. So, in Selvi case, Supreme Court has categorically held that right against inhuman treatment, right against cruel punishment, that is human right provided under Article 5 of UDHR, protection against inhuman treatment, protection against cruel punishment. So, in Selvi case, Supreme Court for the first time held that narcolepsy test or brain mapping test can only be conducted after the consent of the accused. So, this is all about your Selvi case. Now, come to Supreme Court guidelines for protection of rights of accused. So, we will try to understand that what is the role of Supreme Court in protection of rights of the accused. So, with the help of these two important case laws, we will try to understand how D.K. Basu case has been effective in providing in protection of rights of the accused. So, in D.K. Basu case, Supreme Court for the first time in 97 has issued various guidelines for the protection of the rights of the accused. I would like to highlight three important guidelines of this case, that investigating officer will have to prepare arrest memo, and in that arrest memo the time, place, name of accused, age, address, and time and place must be specifically mentioned, so that the constitutional mandate about production of accused within 24 hours can be calculated, time can be calculated from the time of arrest. So, arrested person must be produced within 24 hours. So, for that purpose arrest memo must be prepared by arresting officer. Arrest information must be given to the accused or relatives of the accused, or father or mother of the accused must be, arrest information must be disclosed, must be given to the relatives of the arrested person, so that police cannot commit any atrocity or violence, custodial violence. So, for that purpose Supreme Court has given this guideline, so that arresting officer can inform the relatives of the arrested person. Discovery memo is also important under D.K. Basu case. Supreme Court has said that discovery memo shall be prepared by investigating officer. Investigating officer will have to prepare discovery memo, and in that discovery memo each and every article, each and every substance must be specifically mentioned by investigating officer, because this discovery memo would be helpful for the court, trial court, to decide the case, to draw inference. So, that is why Supreme Court, considering the gravity of matter, has issued this kind of direction. Protection against illegal arrest. So, this case, as you all might be knowing, that D.K. Basu case is case regarding protection against illegal arrest. So, this is all about your Supreme Court guidelines of rights of accused. Now, Come to another important aspect of rights of accused. You all might be knowing that legal representation and free legal aid, these two important things are important component, where accused who appears before the court or is brought before the court by police is poor. He cannot engage his counsel advocate in the court of law, then whether application is made by the accused or not, judicial magistrate is obliged to provide counsel free of cost. So, right to free legal aid is another important right in the hands of accused, and you see the golden rule of criminal jurisprudence is presumption of innocence. Every person is presumed innocent unless his guilt is proved before the court of law. So, because of that presumption, all the benefits which a law abiding person can claim, all the rights, remedies can also be claimed by an accused except few fundamental freedoms. So, you need to remember that arrested person, I have chosen this topic, rights of arrested person. So, you must understand that arrested person has right to know the ground of arrest, he has right to have a counsel, he can take legal assistance from the accused, from the advocate, right to medical examination, right against ex post facto laws, right against self incrimination, right against double jeopardy, right to bail, right to appeal, right to medical examination. So, these are certain rights which accused is entitled to avail under Indian criminal justice system. And most important thing is that Supreme Court has given so many judgment, so many judicial pronouncement, wherein Supreme Court has categorically highlighted the plight of accused and police atrocities, custodial violence. So, in order to protect rights of the accused, in order to prevent custodial violence, police atrocities, Supreme Court issued guidelines in Joginder Kumar case, Joginder Kumar versus State of UP, D.K. Basu versus State of West Bengal. You all need to remember all these things, all these cases, so that you can justify your argument. And default bail, I have also highlighted default bail, when a person can claim bail just because of default of the arresting officer, investigating officer. So, after having all these things, if you are able to connect all these things, constitutional laws and CRPC, constitutional provision and role of Supreme Court, how Supreme Court has given recognized this right to free legal aid as a fundamental right, right against torture, Article 5 of UDHR. I have also referred that international instrument, Article 5, presumption of innocence, Article 11 of UDHR, every person is presumed innocent unless his guilt is proved before the court of law. This is golden rule of criminal justice system. So, you must refer all these things in your examination, and if you all remember all these things, I do believe that you can get success in your coming examination. So, with this I would like to conclude my lecture. Thank you all.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you a very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high-ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance, they should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in-depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.